Hello, everyone. Welcome to Queer Lawyers Speak, hosted by LAGBAC, Chicago's LGBTQ plus bar association. My name is Adam Zebelian. I'm the current president of LAGBAC, Chicago's LGBTQ plus bar association. I'm also a partner at Schiller, DeCanto & Fleck, where I practice family law. Today's topic is LGBTQ plus judges and their path to the bench. And I just happen to have two of my favorite people in the world here that are also judges, Judge Marubio, directly to my left, and Judge Pauel. Welcome, both of you.
Thank you. Thanks for having us.
Judge Marubio, let's start off with you. Can you kind of talk about where you sit, what cases you hear, and just explain your day-to-day as a judge?
Certainly. I'm assigned to the Layton Criminal Courthouse. I'm the acting presiding judge of the pretrial division. So we hear all first appearance cases. That means that people who have recently been arrested are going to court for the first time within 24 or 48 hours of their arrest typically. And they're seeing a judge to determine whether or not they will remain in custody or be released from custody pending trial.
So in layman's terms, you're in charge or oversee bond court.
Yeah, that's what it was called. It was called Central Bond Court, but with the new Pretrial Fairness Act, now we call it First Appearance Court, because bond is usually in people's minds tied to money, and money is no longer a condition of release.
Understood. And we'll talk briefly about
Sure.
the Pretrial Fairness Act later on in the show. But before then, Judge Pauel, can you give the audience an introduction as to where you sit and your day-to-day?
Sure. I sit in the Juvenile Justice Division over not too far from here, actually, over on 1100 South Hamilton. It also houses the Temporary Juvenile Detention Center. And I hear cases essentially of juveniles who commit crimes. So we, from the beginning, arraignment until trial or a plea, and then we also have the children who are on probation or supervision. We keep those cases before us.
So you're both out judges. You're both LGBTQ.
Correct.
How long have each of you been on the bench? Judge Marubio.
I got on the bench in 2016.
And what did you do before ascending to the bench?
For most of my career, I was in private practice focusing on state and federal criminal defense. I also worked for a state agency for a short period of time, including a brief stint as an administrative law judge and ethics officer at a state agency.
Now, what's an administrative law judge?
So in my particular role, I heard cases that involved various licensed professions, such as physicians, accountants, architects, and those trials, those hearings, revolved around whether or not that person's license should be disciplined based on some kind of violation of their standards of care or another violation of the statute that regulates that profession. It's a hearing officer of sorts, because the next step after the administrative hearing would be to go to chancery. So the trial court and the circuit court is actually the appellate court for an administrative hearing.
And chancery is a division of the Circuit Court of Cook County.
Correct.
Where elected or associate judges sit.
Right.
So an administrative law judge isn't actually elected by the
Correct.
population.
We're appointed by the executive branch. We're an executive branch function, not a judicial branch.
Okay, so you're appointed by the governor? Okay.
Correct.
And then once you got on the bench in 2016, what assignments did you have?
So I went to traffic. That's where all the judges start, to learn how to manage a call and learn how to just be a judge in the simplest way. From there, I went to the Domestic Relations Division, where I sat for a year and a half in an individual calendar.
And I appeaed in front of you one time. I was taking notes for my boss, but I was standing at the bench.
It was memorable for me, too.
Is that why you decided to leave domestic relations?
I had an opportunity. The chief judge was creating a new division called the Pretrial Division, and was removing bond court functions from First Municipal into its own entity, with the focus on being more true to the statute and the language in the statute, which said that there was a presumption that people would be released, and they would be released without having to post money. So we went in there to change the culture of bond court, and then eventually the law caught up with our efforts for the PFA. So I left voluntarily.
And you're what's called a presiding judge.
I am.
So you're a supervising judge.
That's right. I oversee a team of 8 judges and 2 staff. And my job right now is about 85% administrative, though I still am on the bench.
And how many presiding judges are there in Cook County?
Oh, I think there's 17. One
There's
for,
a lot.
One for each division. In Judge Pauel's building, there's 2 presidings for child protection and juvenile justice.
Correct.
Then each of the 6 municipal districts have one. Then, of course, domestic violence, domestic relations, chancery, probate, law. There's a lot of us.
And I think, excuse me, I think you're one of 3 presiding judges that are out. Is that right?
I think there's 2.
There's 2.
Yes, it's me and Judge Rice,
Okay.
I believe.
And I think she's going to join us
good.
at a future date.
Sophia.
Oh, you're right. There's 3. Sorry, there are 3.
But that's pretty good.
It's great. That's it's good representation.
And I think that's a testament to Chief Judge Evans' goal of diversifying the bench.
Absolutely, he wants to hear from all voices, and it's important to him to have a cross representation of the county on the bench.
Judge Pauel. Now, I don't know if Judge Marubio even knows this, but you were actually I interviewed with you when I was a law student.
That's right.
At the 2007 Lavender Law. And in fact, that was my first interview ever for any job. Well, that's not true. I had jobs as a kid, but like a professional interview. And I think it went pretty well.
I don't think we spoke very much about the job at all. I think once you sat down, we had a good rapport and we just started chatting.
Yes, yeah, it was definitely memorable. So, Judge, at that time, you were with the city.
I was with the Corporation Council, correct, for the city of Chicago. And before I went to the city, I was in private practice at Sacknoff and Weaver for 3 years, from 91 to 94. Sacknoff is now Reed Smith. So, and then I left and went to the city, and I was at the city for 20 years before I took the bench in 2014.
What were you practicing at the city with the corporation?
I had the good fortune of being in many different divisions. I started off in municipal prosecutions, so I was one of the attorneys in the branch courts prosecuting the municipal ordinance violations. I also worked in the tort division. I worked in the division where then we get FOIA requests and have to respond to those. That's where I ended.
Okay. And so you got a lot of trial experience.
A lot of trial experience, not in torts is where I did the most trials in terms of jury trials and the like. In branch courts, a lot of just bench trials. You don't do too many, huge cases there.
It's nice as a practitioner to be with 2 judges that actually practiced and were litigators. It's always nice to have those type of individuals on the bench because they know what it's like to try a case and the pressure that is litigation.
Yeah.
So then, Judge Pauel, when did you get on the bench?
I got on the bench next month will be 10 years ago.
Oh, wow. I remember when you got on the bench. I can't believe it's been 10 years.
I can't either.
And so what have your assignments been since joining the bench?
Like Judge Marubio, I started in traffic, and then I was assigned to the housing division where before I was there, we did the rotation. I sat in evictions for a little while, in contracts and torts for a little while, just jumped around First Municipal, and then I was assigned.
That's because traffic was part of First Municipal at the time, right? It wasn't separate?
That's right.
Yeah.
That's right. So we rotated, and I actually appreciated that because I felt like I was getting a little glimpse of what everybody did, and I just thought it was good experience. And then I got assigned to housing, and I thought, this is where I'm going to be. When I got my plaques put on the bench and on the wall. And then I got a call from Chief Judge Evans one day saying, we want you in juvenile. And I was perplexed. And I went over there, and it was an absolutely fantastic assignment for me. This is where I still sit, and I hope to continue sitting here for a while longer.
You've been in juvenile court for a while now, right?
Yes.
How many years?
About 9 years now.
Oh, wow. Almost the whole duration
whole.
of your career as a judge. I'm sure it's very rewarding, but also stressful.
It's emotionally trying, but it is also, I think it gives me a sense of purpose, and I really feel that it's somewhere that we need to have people who understand the juvenile mind and understand that as much as we want to fix all the crime in society, we have to understand that trauma and the juvenile mind are all at play when we're dealing with what we're facing here in Chicago right now.
And as I was a state's attorney, I never rotated through the juvenile courts, but state's attorneys staff your courts. It's a whole nother system, the juvenile system. For those of the watchers that don't know what juvenile court is, at least on the criminal side, can you give just a quick summary of what the difference is between juvenile criminal court and adult criminal court?
So unlike almost everywhere else in the state, in Cook County, we have split juvenile courts so that we have juvenile justice, which are essentially children who commit crimes and are being prosecuted. And then on the other side, we have what we used to call abuse and neglect, and now we call, what do we call them?
Child protection.
Child protection. And so separate judges are assigned to the different divisions. We don't cross over. Those judges are responsible for when children are neglected, abused, or other circumstances in the family where they perhaps are made wards of DCFS, or we have services come into the home to try and help the family stay together and keep the children together. On the side where I am, when there are crimes committed, we start with arraignment, where you either charge the minor or sometimes divert them. We put them on pretrial services, try and start providing them with services so that while the litigation process lingers, they are still being provided services to try and address the needs that they have immediately. And then if we have trials, we hear those cases, and then we sentence, and then if they're put on probation, we will have them anywhere up to 5 years on probation.
And the sentences they can only be incarcerated as a juvenile up to the age of 21, is that
Correct.
right? Okay.
Correct.
So I think that's a good segue into the Pretrial Fairness Act.
Sure.
There's a lot of talk in the media about it. You are the supervising judge over the largest bond court system likely in the country. So just give a little summary of what it actually means, because
Sure.
there's a lot of misconception out there of what it actually means.
Yeah, so a lot of the procedure is the same as it's always been. A person is arrested and processed at a police district. Charges are approved by some entity in Cook County. It's felony review. Did you ever have the pleasure of rotating through?
I rotated around felony review.
Congratulations. So someone has approved the charges. That person's then been brought to 26th Street, 26th in California, where they're processed through the Cook County Jail. There's a mental health screening and a health screening. A public defender. We pre-appoint attorneys from the public defender's office in Cook County, and that's so that everything works efficiently, because there's a presumption that when you're in custody, you don't have access to your funds, and you're entitled to an attorney. So a PD will interview the person. Someone from our probation department or pretrial services will interview and prepare some documents for court. Court starts at 12:30. By 12:30, the state's attorney has made a decision. Let's say we have 100 cases that day. They've decided that these 15 people, the charges are serious enough, the background is bad enough, that they're going to file a petition to detain. We're going to put that over in this bucket. Everyone else is going through our first appearance courtroom, where they will be released with conditions. And just as before, the conditions are: you got to show up to court, you can't commit another crime, you got to follow all court orders, such as staying away from a certain address or a certain person, and you got to make sure that you keep in touch with the clerk's office in terms of what your address is. And that's it. They'll be given their court date, and some of them will leave with a pretrial program, but many will be released on those minimum conditions. The people who are put in the detention bucket go to a different courtroom, and they have a much lengthier hearing, because the state has to prove several things in order to detain that person. And it's very similar to how the statute was pre-PFA. It's driven by the state. The state has the discretion on who to file. A judge cannot detain someone without that petition. So again, it's the state's discretion. During that hearing, the state will give the judge evidence to prove that this is the person who committed the crime, that this person poses a danger, and that detention is the only way to keep the community safe, that there's no conditions that person could be put on. If they've proven all three of those prongs by clear and convincing evidence, the person will be detained. Of course, the defense has an opportunity to raise defenses, to bring in mitigating information, and make legal arguments. But that's the gist of the hearing. And at the end of that hearing, the person, again, is either detained or released.
So unlike the old system, it's either all or nothing.
That's it.
Either the person's getting detained or released, and it's based on the filing of the state's attorney, the prosecutor, and then the determination by the judge after that hearing.
Yeah, and before the PFA, the state still had to file a petition to detain. Okay, it was called a discretionary petition to deny bail. Now, what you saw in the past and what you saw all over the state, not just in Cook County, were these very high money bonds as a way to work around whether or not you were detaining or releasing someone. It was sort of a fiction to say, well, bond is set at $1 million. Some people could post that, right? So they were getting out. So if the idea was to detain the person, that failed. Or in the alternative, bond is set at 5,000 D, meaning they had to post $500, and your idea was I'm releasing them, but they didn't have the money. That worked as a detention order. So it wasn't working.
So the PFA, as it's typically called, the Pretrial Fairness Act, takes money completely out of
Totally
the
out
bond
of the
system.
picture. And
so it
it's-
doesn't matter if you're rich or poor. It's
Correct.
It's based on a determination whether you're a risk to the community or if the conditions of bond are sufficient to ensure what needs to be insured before trial.
Correct. And if you really look at these D bonds, deposit bonds, which were money bonds, I want people to remember that a deposit bond was a judge's order to release that person. It's just that they were being released on all those mandatory conditions I said, plus the condition of posting money. So D bonds weren't detention orders. They were release orders.
D bonds meaning I'm setting your bond at this level, you have to post this much in
Yeah.
cash. It was still the intention to release that individual.
Exactly.
Understood.
So now that's gone.
Okay.
And it mirrors now the juvenile system and really our federal system too.
Oh, really?
Yeah.
Oh, I didn't know it mirrored the federal system.
Yeah, there are different sureties allowed in federal court, but typically a person is released or held.
Okay. Well, it definitely levels the playing field
Yes.
because, like you said, judges were setting bonds at $1 million, hoping to keep this individual in custody. But if they were well off, that didn't happen.
Right.
Or setting a low bond, hoping that they would be released. And if they were not well off, they were detained.
Exactly.
So it definitely does level the playing field. Judge Pauel, has this impacted the juvenile system at all?
No, it hasn't because we never had bonds in juvenile court. The juvenile judges have been, since the beginning of time, that's the determination we would have to make. When the minor comes before the court initially, and honestly, I think sometimes that was the most difficult decision that's ever made, is do I hold this child in the jail? Do I release them on electronic monitoring, but let them go home with, knowing that there's parameters that they have to stay within the home? Do not have any conditions at all. And it really depends on the circumstances. It depends on, is there prior cases? Are there prior arrests? Do they have family support? Are they a ward of DCFS? Do they have services available? Are they enrolled in school? So there are many factors that we look at to determine what do we need to do here. And because they're juveniles, the hope is always that you're going to use the least restrictive method necessary.
And that's the same language in the adult statute. Least restrictive conditions. That's the goal.
Yeah.
It's electronic monitoring,
Yeah.
EM as it's usually
Our
referred
most
to.
restrictive condition.
Okay, so EM is not implemented in all cases. That is at the discretion of the judge.
So electronic monitoring, since it's regulated by the Sheriff's Department, means that person's in the custody of the Cook County Sheriff. They're just at home. But they are
I see.
monitored by the Sheriff. They are beholden to the rules of the Sheriff, meaning their house can be searched at any time. They have a requirement to charge their band regularly. If they have movement outside of the home, if they overstay or leave without permission, that's a violation. They can have an EM hold and be brought back into custody. It's very restrictive. It is not used, and it's not really appropriate for everybody. There's a risk of under-conditioning people when we release them, not putting enough restrictions, but there's an equal risk of over-conditioning. And we found that the best pretrial outcomes involve conditioning appropriately. So using EM as some kind of safety valve is not effective.
So EM literally means your cell's your home.
Correct.
And so you lose all rights of privacy. They can treat you just as if you were in custody
Exactly.
of the jail. Interesting. I did not know that.
I will tell you that it's not quite as restrictive in juvenile court. The sheriffs don't go into homes. There's none of that. We have somebody who monitors, and then generally if there's a violation, they inform the state's attorney, and then they determine whether they're going to file a motion to revoke the electronic monitoring or not. So then they have to come before us. We make a determination as to what's going to happen. And I think you have to remember that juveniles are different, right? We expect that juveniles don't have mature minds, and they are going to, just by virtue of the fact that they're teenagers and their brains are changing and they're very high risk, they're going to be infractions. They are going to have violations. And
their home environment's not always within their control.
That's right. Yeah. And sometimes their home environments are actually part of the reason that they're violating electronic monitoring. So there's all kinds of factors that we have to take into account. And I think that's why juveniles, hopefully we are a little bit more understanding sometimes of what's going on.
So you take it out of the law enforcement
Correct.
realm
That's right.
and more social service realm.
That's right.
So to shift topics a little bit,
I'm ready.
as a out LGBTQ plus lawyer who met both of you years ago, you both are role models to many of us. You have always been out. I met you out. You're leaders in the legal community and have been as out individuals. Why do you think it's important for there to be a diverse bench and specifically out LGBTQ plus individuals on the bench?
So I don't think of it anymore as why it's important for me to be out. I made a decision to live and to be happy with who I am, and being out is part of that, simply. In terms of representation on the bench, the Victory Fund, which is a PAC, an organization that does political training for queer candidates, has a saying that representation is power. And that's true. Having us in places where there are conversations being held about the policy of juvenile court as it might affect queer youth, about policies in the criminal side as it might affect queer people. It's really important for us to be at the table having those discussions and raising issues. Just a simple example. Let's say that there's a sentencing program or a probation program, but the program is gendered, meaning the program is divided between men and women. Where do our queer siblings go if they've been sentenced to that? And raising those issues along the way.
That's right.
To make sure that all of us can be treated equally in the court system.
Judge Pauel?
I would have to go along with that. I mean, there's not really, in terms of, I'm just going to go with that.
Thanks. I got a
It was well said.
I got a rubber stamp.
And I know you two are best friends, so you think alike.
That's right.
Judge Marubio, I know you have some questions for us to answer. I've never had a guest ask questions, but I'm down. I'm ready.
I think these are just some lightning round questions.
Okay, and I don't know what you're going to ask.
I know, that's okay. I'm going to start with Judge Pauel. Judge Pauel, Tig Notaro or Fortune Feimster?
Both.
Okay.
Tig.
Tig, you're going to take Tig. Okay, your choices are L, G, B, T, or Q.
L.
Okay. Gaydar, real or make-believe?
Real.
Pride Fest or Pride Parade?
Pride Parade.
Women's soccer or WNBA?
No, that's both.
Okay.
All right,
Adam.
my turn.
All right. Name 3 LGBTQ judges, other than us.
Matt Janish,
Okay.
Mariana Reina,
Good.
Jill Rose Quinn.
Nice. Email, delete as you go or keep them all?
Keep them all.
Oh, wow. Would you rather fly or be invisible?
Fly.
All right. Text or call?
Text.
All right. Time machine. Do you choose the future or the past?
Past, I think.
Okay. Long hair on guys, yay or nay?
Depends.
Now, this one,
Nay on me, but
just be careful on this one, okay? Short hair on women, yay or nay?
Depends.
Be careful, I said.
Yay here, but
All right, that's all I had for you.
all right. Well, I think we are all set here, and I want to thank both of you. It's been an honor to be in your presence. I look up to both of you, And I hope I can do what you will all have done for the community in my career.
You
So,
are. You're doing an incredible job with LAGBAC.
I hope one
You're a
day
wonderful leader.
you will be one of our co-judges who will be sitting actually in the other seat.
Well,
So-
that means a lot to me. That's the ultimate compliment. So thank you.
Okay.
Thank you very much.
Thanks, Adam.
Thank you all for joining us. It's been an interesting conversation here with two fabulous judges. Thank you again, and I'll see you next time.